Hello, everybody. You're watching the virtual amicus, and I'm Jay Lodha. False FIRs are being lodged at the drop of a hat. Doctors are being prosecuted, even if there's no breach of duty of care. So today we'll be covering certain segments with respect to civil negligence, criminal negligence, role of state medical councils, and how false cases are being filed. What are the remedies that are available to a consumer, and different statutes that are governing the same. So let's quickly start our discussion. I've divided my presentation into certain segments. So first I'll be dealing with consumer protection as a whole, and in particular with the Consumer Protection Act, which is of 1986, and now which is subsequently succeeded by the Consumer Protection Act of 2019. So let me first start my segment by defining what the Consumer Protection Act is. So it was passed in the year 1986, and it was passed with the intention to provide better protection of interests of consumers, to offer better protection of interest of consumers, as well as to protect them against certain defect in goods and deficiencies in services. There are certain unfair trade practices that are happening, so it was like a safeguard to all the consumers. So the main objective of the Consumer Protection Act 1986 was to render a simple, inexpensive, yet speedy justice process through a three-tier quasi-judicial mechanism, which will be there both at district, state, as well as at the national level. Now, as we all are aware, that Honorable Supreme Court in Catena of judgments, in a plethora of judgments, has held, and I quote, and has recognized that right to health is a fundamental right, which is enshrined under Article 21 of the Constitution of India. But unfortunately, we as a civic society have completely and miserably failed to provide justiciability to this right. Now, let me bring your attention to the Act of 2019 of Consumer Protection Act. What happened in the year 2019 was the era of digitalization and rapid growth of e-commerce that took place, and there were certain fresh set of challenges that were required to be addressed by consumers in the digital age. So the government then passed what we call as the Consumer Protection Act of 2019. It came into force on 24th of July 2020, and it subsequently replaced the 3-decade-old act which was prevailing at that time, which was the Consumer Protection Act of 86. Now, obviously, this legislation was brought into effect so as to the sole intention to better protect the interest of the consumers by providing easy dispute resolutions, tribunals at district, state, and national levels. There were certain consumer councils that were established, again at district, state, and national levels, to work for the purposes of consumer welfare. So the overall experience that was gained, prior to this enactment that took place, it was taken into consideration, and subsequently this new enactment was put forward and passed. Now, it also led to establishment of what we call as Central Consumer Protection Authority, the short form, the abbreviation being CCPA. It led to its formation as well. And there were certain changes as well in the definition of the term or service. Now, the definition of service under the Consumer Protection Act is very crucial for the purposes of the Act. Now, it was defined in the Act of 86, and I quote, under Section 2O, and I'll be reading out the definition, which meant service of any description which is made available to potential users and includes, but not limited to, the provision of facilities in connection with banking, finance, insurance, transport, processing, supply of electrical or other energy, board or lodging or both, housing, constructions, entertainment, amusement, and etc., but does not include rendering of service which is free of charge or under a contract of personal service. Now, what happened was there was a suggestion that was made in the by including the term healthcare in the Consumer Protection Bill of 2018, which was included the connotation of the definition. But subsequently, in the Act of 2019, the word healthcare was deleted, or it was removed, from the definition, Section 2, subclause 42 of the Act. So there was a speculation initially that the Act of 2019 will not be applicable to medical services, and the omission of the term healthcare does not apply, that the Act would not be applicable to medical services, but it continues to apply to medical services, even at concessional rates. Now, there is a landmark judgment of the Honorable Supreme Court I'll draw your attention to, which is the Indian Medical Association versus VP Shanta. And what did the Honorable Supreme Court hold in this very judgment? It held that it basically brought the medical profession within the ambit of service as defined in Consumer Protection Act. So there was a recognition that was given between the relationship of patients and medical practitioners, and that recognition of relationship was termed as contractual. So basically, the relationship that the doctors or the medical professionals shared with the patient became contractual. So during the course of the treatment, if patients suffer any kind of injury, so they could sue doctors in procedure that is free from protection or subsequently claiming for compensation. So that will be, now I will define what contract for service means and what contract of service means. So contract for service basically implies to a contract where one party undertakes to render services such as professional or any kind of technical service to another, where the service provider is not subjected to direct control or detailed direction. So a contract service implies basically to somebody like a master and servant relationship. So the contract of service is beyond the ambit of Consumer Protection Act, because the master there will be culpably and hopefully liable. So the Consumer Protection Act will not come to rescue of patients if the service that is rendered to these patients is free of charge, and only if they have paid a nominal registration fee. But in cases when it is waived due to incapacity to pay, the grievance will be registered and dealt with under the provisions of the Consumer Protection Act. So now we finished reading through, skimming through the provisions of the Consumer Protection Act in light of and keeping in the backdrop of law and medicine. Now we'll head to what we call as civil negligence. Now, what does the term negligence mean? There are a number of definitions that are available of the term negligence. The most basic explanation that I can give of negligence is breach of duty of care or omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, which would do, or doing something which is prudent and a reasonable man would normally do. So basically it is a tort. Negligence is a tort, and which refers to a breach of legal duty to take care, and it has to result in some kind of damage. Now, if there is no damage, then doctors or the healthcare cannot be sued. So negligence is basically a tort which refers to a breach of a legal duty to take care, which results in some kind of damage, some kind of a wrongful conduct that leads to some kind of forceful harm on that person. And when that practitioner knows that such an act would result in some kind of harm. So in short, to sum it up, if there is no harm, then there is no negligence. So damage is an important ingredient to what we call as negligence, to bring it under the purview of tort. So what is medical negligence? So basically, when a healthcare worker or a practitioner who stays away from recognized standard of care in the treatment of a patient. So if a doctor is treating a patient, there is a standard of care, there's a protocol that he is required to maintain. So if there is even slightest of the deviations that subsequently results in some harm that is caused to the patient, it would be called medical malpractice, and subsequently the doctor will be guilty of negligence under the provisions. So standard of care is defined, and I'll reiterate what a reasonably prudent practitioner, medical practitioner would do or would not do under certain same or similar circumstances. So civil negligence is basically when Consumer Protection Act ends. That is where civil laws come into play, and that is where the law of torts take over and protect the interests of the patients. So this and the best part is that it also applies in cases where services have been rendered or treatment has been offered which is completely free of cost. So that is where consumer protection does not apply, because consumer protection, there has to be some fee that is charged, there has to be some consideration, monetary consideration that is involved. But in case of civil negligence, even in cases of free services in the form of free treatment, uh, the provisions of under civil laws would apply, and the law of torts would take over. So even if a service is free, then also these provisions will prevail, and a patient can obviously take recourse to law in such matters of negligence under a law of torts, and he can claim compensation. So if the damage is caused, a person can claim compensation under torts, but it is the onus, initially it is the patient that has to prove that the doctor was negligent and the injury was caused as a result of doctor's negligence. So two things that the patient is required to prove. Number one, doctor was negligent in discharge of his duties, and number two, there was an injury that was a consequence of a doctor's negligence. Now there are different kinds of negligences. There could be transfusion of blood of some incorrect blood group. Suppose A positives are guided and the doctors end up giving some other blood group or injecting it, or leaving something behind after a surgical procedure in the abdomen, unsuccessful sterilization resulting in resulting in the birth of a child, some kind of a defect happening there, then removal of organs without taking the consent. There is a consent form these days that is required to be filled. So if the organs are removed without taking consent, then that can attract negligence. Then operating a patient without giving him anesthesia, then etc. and etc. Also in cases when some wrong medicine is administered and that results in some kind of an injury which proves to be fatal for the patient. So basically the remedy here is to claim compensation, and it is includes the claim for compensation that is in the form of compensation. So if there's a breach of duty, then the hospital staff or the medical staff, they can be held vicariously liable for such wrongful acts that they commit, and damages is a result of such acts in the form of compensation. So sometimes there are certain senior doctors also that who are held liable for the acts of junior doctors because they are working directly under their supervision. So there is some employee in a hospital, and the hospital will also be responsible if the employee hurts the patient by acting incompetently. So, and that is how the negligence works, and that is how damages are claimed. So there are certain times when some specialists go wrong during the course of their treatment. That is when damages can be claimed and attracted as a form of a penalty. So one has to be very careful in discharge of medical functions. And one thing has to be noted, which is very important, that a doctor or a medical practitioner may also be liable for negligence, but not only for negligence, but also for mere carelessness or want of attention, or cases that make him criminally liable. So there has to be a distinction that has to be drawn. It's very important to understand that the hazards of medical professionals that are exposed to, sometimes civil liability, which is not extending to criminal, but they're unfortunately held criminally liable. So in case of criminal liability, which I'll be addressing later on during the course of my presentation, there has to be some gross negligence and some gross harm, recklessness at the part of the medical practitioner that exposes them the risk of imprisonment for alleged criminal negligence. So there has to be certain deviation from their standard duty of care to attract negligence or some kind of rashness in their judgment. And that is how it is. So there have been a number of plethora of Supreme Court judgments in that effect as well, as to what civil negligence is, what criminal is, and there has to be a certain distinction, because day in and day out we see false cases being registered under doctors, against doctors. They're being forcefully prosecuted for acts, omissions, or crimes that they've never committed. A simple breach would lead to some criminal liability, and which is the most unfortunate thing, because doctors are frontline healthcare warriors, they are heroes, and thanks to them that we're in a better state today. So one has to be very careful in instituting, as far as institution of cases against them is concerned, and as far as courts have to play a pivotal role to safeguard their interests, to safeguard their rights as well. So now we just finished, we'll be now discussing criminal liability. We earlier discussed Consumer Protection Act, we discussed civil negligence, and now we'll be discussing criminal liability. Now, when is a doctor criminally liable for his acts? Now, we need to understand one thing, that there is a huge difference between civil liability and criminal liability, because criminal liability attracts sentence. You know, a doctor can be, or a medical practitioner can be sent behind the bars for his acts. So it has to be so blatant, the negligence, that it invites certain criminal proceedings against a doctor. And there's a section under the Indian Penal Code, which is section 304A, which defines it as a doctor who causes death by way of a rash or a negligent act, and that results in a death, and a doctor is not qualified to operate. So basically, whoever causes a death of any person or by a rash or a negligent act which is not amounting to culpable homicide shall be punished by way of imprisonment for up to 2 years or fine or both. Now, what is one thing, I'll pause here for a minute. What is important to note here is that the negligent act which is not amounting to culpable homicide shall be punished by virtue of imprisonment up to 2 years, fine, or both. Then there's a landmark Supreme Court judgment on this, which is Spring Meadows Hospital versus Harjol Ahluwalia. It states that there is a certain standard of negligence that is required to be proved against a doctor in cases of criminal negligence, so as to attract criminal liability against doctors under Section 304A of the Indian Penal Code. And it has to be so high that it can be described as gross negligence or recklessness, not merely a small breach of duty to take care, or not merely lack of necessary care that is required. So the patient has to die basically due to the error in judgment or accident by a doctor while performing or the treatment on the patient. So death is also pivotal in cases. So every civil negligence, if I sum up, is not criminal negligence, because civil negligence, in order to attract criminal liability, has to be of gross nature. There has to be gross recklessness on the part of the doctor, and mere deviation would not suffice. So very rarely you will see that a doctor is, prosecuted for murder or attempt to murder, because ordinarily a doctor will not have the motive or will not have the intention, mens rea or actus reus to say, to qualify and kill a patient. Why would he do that? The patient that he's operating upon, his intention would be to cure him, to relieve him of all the problems and sufferings that he's been through. So we need to understand that there has to be a guilty intention to attract offenses like murder and culpable homicide, which ordinary care does not attract, because a doctor is like is treating on a patient to cure him of the illnesses. So a doctor at the max can be booked under or for grievous hurt or other offenses that involve causing of hurt. Now, there are certain sections under the Indian Penal Code that provide immunity to a doctor from criminal prosecutions, such as Section 87, Section 88, 89, 92, which are in good faith, and for the which have done certain exercises that a doctor carries for the betterment of the patient, have done for the benefit. A doctor has done it on purpose, and that can be a good ground of defense. So for doctors, so as to say. So, and there is another principle that I would draw your attention to, which is principle of res ipsa loquitur, which means that thing speaks for himself. Now, it is well accepted that in cases of gross negligence, the principle of res ipsa loquitur is to be applied. So it is essentially an evidential in principle, so as to assess the claimant, wherein there is a defense on the part of the claimant that things are speaking for themselves. So, for example, while deciding the liability of a doctor, it has to be well established that the negligence pointed out or should be that of breach in due care, which an ordinary practitioner would have to be able to keep. So that is one of the maxims. Now we come to how to. So basically now I'll be talking from a doctor's point of view as to how a doctor, medical practitioner, a healthcare unit, or a hospital can, avoid litigation. So how to avoid litigation, because day in and out, as I said before, that there are so many cases being filed against doctors, hospitals are being sued, criminal negligence is being alleged, every single day, and you see a lot of doctors attending hearings. Unfortunately, they should be in the hospitals instead of being in courts. And this is the last thing that we want to see, that a doctor is being sued for an offense that he never committed, and he's serving a sentence that he never deserved. So there are certain pointers that I've prepared that can probably be of good help to every healthcare. And there are certain steps and strategies in order to avoid malpractice of lawsuits that are being performed on their jobs. Number one, to establish, a good patient doctor relationship. So know the person in and out, to understand what their background is. Number two, to be clear, consistent in their diagnosis, to try and visualize what a diagnosis will lead to. Obviously, a doctor knows better than all of us, so there, that is pretty much clear in itself, and self-explanatory. Then getting informed consent. Now, consent forms these days are everywhere, for smallest of these surgical procedures that are carried out to large massive operations that are done and performed. Consent has to be taken, informed consent from the person who is in his senses to give so. Then there has to be a complete, accurate, and complete documentation of all the records that a patient has before he's undergone any kind of treatment. Then being prepared, staying current, following proper procedures, and then obviously using alternate remedies like mediation, conciliation, negotiation, to try and settling out the dispute with the patient and his family, rather than contesting matters in court of law. I think it's always better to settle it out, to understand what went wrong and how things can be sorted in a peaceful and a very amicable way. Now, in our last segment, we'll be discussing role of medical councils in negligence, and what is the role and why were they enshrined. So the Medical Council of India was set up in the year 1934 under the provisions of the Indian Medical Council Act of 33, which was later revealed, and a new act came into being, came into force, which was called the Indian Medical Council Act of 56. And then there were certain amendments that took place in 64, 93, and 2001. And so and ultimately it was on 25th of September 2020 that it was repealed, and it was succeeded or replaced by the National Medical Commission. Now, there are certain procedures that are adopted by these commissions. There are in-house inquiries that happen, and on the basis of complaints that patients file, and there is an in-house inquiry mechanism wherein doctor or wherein the MCI is capable of suspending the license of a doctor or a medical practitioner if it deems fit, and rarest of the rarest circumstances, because MCI reserves the right to punish. There are once the inquiry is conducted and the complete case is investigated along with the expert panel of doctors, and if the doctor is found guilty of certain charges that he has been alleged again, so he can also be removed from the role of the register, that the state register or the medical register that the state maintains for a particular period of time. But it also can be appealed in a court of law, the order that is passed of punishment. So there are these in-house carries that are inquiries that takes place, and independent bodies come and judge under the MCI regulations by a group of by certain external doctors. And there are a lot of amendments that have also taken place, like for example the Indian Medical Council Amendment Act 2013. And I will not like to bore you or bother you with these intrinsic detail of medical law, because that will obviously be of no relevance. So on that note, I think that'll be pretty much it. And I'll be concluding only by saying that every citizen has to be vigilant, but at the same time has to understand that a doctor's job is in hospitals, is in healthcare units, and not in courts. So please be vigilant, but think twice before prosecuting a healthcare or a medical practitioner. They are doing their level best, and they are carrying out their duties to the best of their abilities. So, it's always better to consult your legal assistant, your counsel, your lawyer, engage him, take his advice, whether there's a case made out or not. Don't just file cases at the drop of a hat against somebody, because if negligence is not established, then doctor loses his very important years of practice, which obviously one would not have imagined or envisaged. So thank you so much for watching this. Hope this was helpful, and stay tuned. The next episode is on its way, Until then, please like, share, and subscribe my channel. And thank you so much for your patient hearing. Thank you. Thanks a lot.